Good morning, everyone. My name is Russ Nesovich. I'm with Nesovich Law with an office here in Morristown, New Jersey and Manalapan, New Jersey. And I want to reach out to you today on January 1st, 2020 with two important messages. The first is obviously I want to wish everybody a happy new year. I hope you had a great end to 2019 and I hope you have a great start to a happy and healthy 2020. The second is a really important tip when it comes to estate planning. On December 20th, 2019, Congress passed something called the Secure Act. And the Secure Act has a number of provisions for dealing with all sorts of things. Most importantly, if we're talking about estate planning, for IRAs. One of the things that it did that was incredibly beneficial for IRA holders is that you no longer have to take RMDs at 70 and a half. You can wait. If you haven't yet turned 70 and a half, you can wait till 72 to take RMDs. But what's even more important from an estate planning perspective is that Congress made changes to the way that RMDs, required minimum distributions, have to come out of an IRA after you pass away. It becomes really meaningful in terms of the beneficiaries that you have for your IRAs and whether or not you've done any trust planning for your IRAs for your beneficiaries. So for example, before the passage of the Secure Act, there was the opportunity to do something called stretching an IRA, where you could leave an IRA to a beneficiary who then, over the course of their lifetime, could stretch those IRA assets. So no longer having to worry about the number of years in your life, but the number of years of their life. So leaving IRAs to very young beneficiaries, minor beneficiaries, your descendants really made an awful lot of sense. The Secure Act changed that, and the Secure Act basically said that for most beneficiaries now, when you pass away, non-spouse beneficiaries and some other exceptions, the assets in that IRA have to come out and be taxed within a 10-year period or over a 10-year period. So planning that you may have done using conduit trusts, other types of trusts, leaving assets to certain heirs specifically for the purposes of stretch may now no longer be meaningful, may no longer be valid. You might want to consider using different kinds of trusts rather than conduit trusts, accumulation trusts, or just thinking about other ways to use your IRAs, leave your IRAs, use life insurance for planning, all sorts of different things that you can do now. But unfortunately, the conduit trust may no longer be the most viable option, especially if you're trying to protect assets for your heirs in the event of a divorce, creditor issues, bankruptcy, those types of things. So if you have any questions about this, whether we did your plan or somebody else did, and you want to take a look at it, review it, make sure that given the passage of the Secure Act at the end of 2019, it's still the best option for you, give us a call. Again, my name is Russ Nesovich. I'm with Nesovich Law. Our number is 856-439-6223. We have offices in Manalapan, New Jersey and Morristown, New Jersey. Thanks so much. We hope to hear from you, and if you have any more questions, just give us a call. Take care.